To today's program, Keeping Arbitration Costs Down. I'm Ala Policastro, Director of Education and Professional Development for the Beverly Hills Bar Association, and I'm delighted to introduce our speakers today, Aaron Gothelf and Stephanie Cubacha. Aaron is the Vice President of the American Arbitration Association's Commercial Division for the Pacific region. He serves as the National Chair of AAA's Entertainment Dispute Resolution Advisory Council and the Western U.S. Chair of AAA's Healthcare Dispute Resolution Advisory Council. Prior to joining AAA, Aaron was the Northern California Regional Director for Judicate West. Stephanie is the Vice President of the Employment Division of the American Arbitration Association International Center for Dispute Resolution. Prior to joining AAA, Stephanie practiced family and immigration law in the Chicagoland area. Stephanie received her JD from the Benjamin N. Cardozo School of Law in New York. We are excited to hear what they have to share with us today, and so I'm going to turn it over to them.
All right, thank you so much, Ala. Appreciate it. Everybody, thank you for joining Stephanie and myself this afternoon with our program, Keeping Arbitration Costs Down. This program kind of came to light as a variation of a program that I've done in the past, basically arbitration efficiency. The promise of arbitration, if you will, has always been a faster, more cost-effective way of resolving disputes than traditional litigation. But we've seen that kind of get a little bit out of control or not be necessarily true in recent years. All right, so the goal of arbitration was always to be a faster, more cost-effective way of resolving disputes in traditional litigation. And what we see now is arbitration starting to really mirror litigation. So extensive discovery, protracted motion practice, highly contentious advocacy, longer case life cycles, higher costs. These are all things that scare attorneys, they scare clients. They're the reasons why people say they don't want to use arbitration because they think it's either cost the same as traditional litigation or potentially could cost more. So, well, this presentation today is going to be provider neutral, as I say, meaning that various ADR providers have some variation in the individual programs we're going to discuss today. These are just good things to keep in mind when trying to control the costs of your arbitration. So a cost-effective arbitration starts with how you incorporate an ADR provision into a business contract. The ADR provision in your contract essentially is the roadmap for your arbitration. And in a lot of ways, it's going to determine costs and whatnot. So the types of ADR provisions that lead to high costs, I always like to say, are first, poorly drafted arbitration provisions. So an arbitration provision that doesn't cite a specific set of rules, maybe applies the wrong rules to a particular dispute type, doesn't clearly lay out who pays for the arbitration, requires a panel of 3 arbitrators instead of a single arbitrator, when a single arbitrator would have been a lot less expensive. Just so everybody knows, the typical 3 arbitrator panel is 4 to 5 times more expensive than a single arbitrator panel, regardless of individual rates and all that kind of stuff. And there's some variation there. Why is that? Because typically the chair has to bill considerably more than the wings, just doing the work supervising the wings. So you have to really think about whether you want 3 arbitrators on an arbitration. Does it make sense to require mediation first? A great way to save money on arbitration is never having to get to arbitration in the first place, right? So you see some arbitration provisions that have what we call a mediation speed bump or a mediation step. This would require the parties to do some sort of early mediation, early neutral evaluation, some type of dispute resolution process prior to the arbitration even being filed. And you'll find that a good chunk of disputes can be resolved relatively quickly in the early stages of disputes just by talking to their side. Which industry rules should I incorporate? Now, whether it's AAA, JAMS, Signature, ADR Services, well, whichever provider you're working with, they all have some variation of commercial rules or construction rules or employment rules. And specifically, you want to obviously select the rules that most closely match the anticipated dispute type because that's going to set out a lot of different protocols and how the case will be handled. Everything from how many arbitrators might be handling your case, to how many days of hearing time you get, to discovery provisions, all that kind of stuff. A lot of these are specific, rule specific. Fixed fee mediation, arbitration versus a standard fee schedule. This is something we're going to talk about a little bit later. Again, most providers offer some form of fixed fee mediation or arbitration. An example would be I saw another provider was running an ad in the local legal publication a couple weeks ago, and it said that they would mediate any personal injury or medical malpractice dispute with a claim value under $100,000, a 4-hour mediation for a simple flat fee of $800 per side. And they had a specialized panel that had agreed to accept that compensation, right? So you know up front what things are going to cost. How does that relate to arbitration? Typically for claim values under a certain threshold, you're going to see providers limit the number of hearing days, limit how many depositions can be taken or any depositions at all, um, establish an efficient timeline. The award has to go out, but within 60 days or 90 days or 120 days of appointment. So things like that are great ways to keep down costs, and you don't have to guess what the arbitration is going to cost because it's not based on some hourly rate selected by the individual neutral. It's based on a set flat rate by the provider. Cost shifting provisions, who pays for the mediation or the arbitration? Again, in most contracts, the general rule is, at least for commercial arbitration, that the fees are to be split between the parties, and if the provision allows for it, you can write the prevailing party is entitled to recoup their attorney's fees or their arbitration costs or their attorney's fees and their arbitration costs. You want to be really specific about that in the arbitration provision about what it is they're entitled to get. Should discovery be limited? This is a fantastic way to cut down on costs in arbitration. Sometimes you'll see an arbitration provision drafted where it'll say, if the claim is under $100,000, each side is limited to no more than one deposition, right? Because we know, especially these days, one side could weaponize potentially the cost of discovery to force the other side into a bad settlement, and that's not good. Should the hearing be heard via documents only? At AAA and at other providers, sometimes when some disputes are just literally over a couple of $1,000s, it makes sense to submit the disputes on paper. Claimant submits their complaint and supporting evidence. The respondent would issue an answer and their supporting evidence, and the arbitrator just, without the need for any type of oral argument, issues a ruling, right? That's going to be very efficient. How will the mediation, settlement, or arbitration award be enforced? It's always going to save you money if you actually have a directive in the arbitration provision explaining that, which leads into the next part, how will appeals be handled? One of the most expensive parts of arbitration is enforcing awards or attempting to vacate awards. So many providers actually have optional appellate rules where if one side's not happy with the award and wants to vacate it, or one side's happy with the award and wants to enforce it, there's a provision, there's a way that the provider can help you with that without you having to go to court and spend that kind of money. Also, whenever you go to court, whatever you've discussed in private in arbitration becomes very public very quickly on a public court document. Then, of course, addressing the issues of what happens when one side doesn't pay, which is a pretty typical tactic to slow or stop an arbitration. So I just did an example here of a fixed rate mediation. Again, it's something that most providers offer some variation of. I had initially drafted this slide as the AAA program with our thresholds and all that kind of stuff, but I have to be neutral here in this presentation. So typically, where it saves you money is there's usually not a filing fee, especially if it's already tied to an existing arbitration. One thing at AAA that we really support is, resolving disputes, helping parties resolve disputes on their own. So if a mediation is going to avoid a full-blown arbitration, you might as well save the money up front, and we all support that here at AAA. Fixed rate compensation for the mediator. In Arbitration and mediation in general, your biggest wild card is going to be the hourly rate of the neutral. In California, I see mediators and arbitrators out there doing things for $200, $300 an hour. I see mediators and arbitrators doing cases for $2,000 to $3,000 an hour, right? There's a huge range as far as what people charge for stuff. And it's usually based on the types of cases they handle and how popular they are. But that can get really out of control. And if the rate is it's a fixed rate compensation, you kind of know exactly upfront kind of what things are going to cost. Holding things virtually, right, is always going to cost a lot less money than making everybody show up to a hearing room center, charging them a room rental fee, charging them a food fee if they offer catering, that kind of stuff. If you're not, if you've been to a provider and been charged an administrative fee or a room rental fee, that's what typically is covering all the external costs, including the food and staffing the place and all that. The mediator could decide to limit or forego pre-mediation statements. I'm not a big fan of this one, but if it's a small enough dispute and a simple enough dispute, at least the mediator thinks so. It's not always necessary to have the mediation statements, but mediation statements in general are usually a good idea. The mediator might actually decide to forego a pre-mediation conference call if they feel they understand enough about the case based on the mediation statements if they ask for those. And then procedures are written with accessibility as a key feature. One thing at AAA and other providers is we don't always have both sides necessarily represented by counsel in actions. Oftentimes you'll have a pro se claimant. The claimant's usually the pro se side, a lot of these things, especially in consumer cases. You want to make the process as easy as possible, whether someone's an attorney or not, whether they understand the law or not. ADR is supposed to be accessible to everybody. All right, this was an example of a fixed rate arbitration. So again, these are going to be for claims or counterclaims under a specific dollar threshold. So don't expect to file your $100 million arbitration claim and have an arbitrator that's going to do it for $300 an hour and limit it to a single day hearing. That's not how it works. Fixed rate compensation, again, for the arbitrator. Fixed rate compensation for the arbitrator could fall in two forms. The provider might cap their hourly rate. They might say for fixed rate arbitrations, all of our arbitrators receive $300 an hour compensation, or they might cap the entire cost of the arbitration in general. So it wouldn't be something billed hourly. It would be, let's say, a commercial expedited case where the total compensation for the arbitrator is $2,000 for the case or something like that. So whether they spend an hour working on it or they spend 20 hours working on it, $2,000 is their compensation, and the parties know that up front. I'm a big fan of limiting strikes on an initial rank and strike list when you're trying to save on costs. The more rank and strike lists that have to be sent out, the longer this process gets drawn out, really the more expensive it turns to be, especially for your clients, if you're constantly reviewing rank and strike lists and then charging them for the time that you're doing that. Limiting discovery and motion practice. Again, for arbitrations under a certain threshold, we talked about, for example, limiting both sides to one deposition or no deposition or doing everything via interrogatories and limiting the number of interrogatories, whatever you might want to do. A ban on site visits, things like that, all things that add the cost of an arbitration. As well as limiting motion practice. Outside of maybe just filing a general dispositive motion at the beginning of the case, something like that. The filing of lots of exotic discovery motions is one of the most expensive parts of the arbitration process, and really starts to raise the cost. Again, for very low claims or counterclaims, you could hear it via document submission. So it'd basically be what we call a paper arbitration. You just hear it on the paper. Requiring the evidentiary hearing within a certain number of days of the preliminary hearing. So these things don't just kind of lay out there in the wind, right? The teams get to them quickly. And then having an award issued within a set number of days of the evidentiary hearing. Sometimes you might have an evidentiary hearing and the parties are wondering where award is. With a fixed rate arbitration, usually in the procedures, this is all explained out what the time limits are for resolving some. Okay, drafting arbitration clauses is your general options. So the arbitration rules to apply in the arbitrator selection process. I The arbitrator selection process is something that I don't see as often in arbitration provisions, but it's going to save parties a lot of time and money if this is spelled out. So whether it's a single arbitrator to be selected via rank and strike list, you can just literally write that into the arbitration provision. So the parties aren't wasting time over figuring out a point method. Or if it's going to be a three arbitrator panel, you write in there that each side has 30 days after the initiation of the arbitration to appoint their party appointed arbitrator, and the two party appointed arbitrators have 15 days to select a neutral chair, something like that. Again, single arbitrator cases are the most cost efficient. Rarely do I think you actually need a three arbitrator panel unless it's an extremely complicated issue and it's a very large claim amount. Arbitrator qualifications, if you're specific in the arbitrator provision about the specific type of arbitrator you're looking for, that's going to make this a faster, less costly process. And you're going to get an arbitrator that has the right subject matter experience for your dispute type. Why is that important? Well, I don't like to think of arbitrators as necessarily being jacks of all trades, right? If you select an arbitrator for your case that does not have the right specific background for that type of a dispute type, they're going to bill you for the time it takes them to learn about the dispute type and to research the case and look at things that maybe an arbitrator that was a little more experienced within that practice area wouldn't have to bill that time for because they already know it. Again, we talked about single panel or panel three arbitrators. Three arbitrators is always going to be typically 4 to 5 times more expensive. Keep that in mind. We've done studies, at least at AAA, as far as you know, a single arbitrator versus a three arbitrator. Does one side tend to win more with one versus three? Are the award amounts greater or less, one versus three, all these kinds of things? And really, there's no statistical difference as far as the number of times a claimant might win versus a respondent might get a judgment or a victory, and the size of the award. So really, you have to really think about why you want three arbitrators. Governing law, and I always write not only substantive law, but the FA or the various state acts that you're going to use. This is especially important when you're obviously dealing with parties in two different states. If it's an international arbitration, you're dealing with parties in two different countries. Again, if this isn't spelled out and you have parties that are in different jurisdictions, then this is another thing that the arbitrator is going to have to ask the parties for briefing on, possibly oral argument, I don't know, and make a decision on. And they're billing you for all that time while they're doing that. Again, it's a waste of money. Spell it out in the provision. Locality arbitration, location of the evidentiary hearing. Listen, one city, one state, one city, one country. Do not put in multiple cities and multiple states, multiple cities and multiple countries. I've seen some of these provisions that just give all these different options, and I guarantee you that's just going to create conflict that has to be resolved either by the provider or by the arbitrator. Again, costing the parties more money for that. Confidentiality issues will be made public and all that. The general presumption is arbitration is supposed to be a confidential process, but there's always going to be situations where the law says it's not confidential. So, for example, I had, I don't know, a big case a couple months ago where a large publicly traded company was issued a $100 million award, and they had to disclose to their shareholders, where the $100 million came from. And the losing side was very upset about this. They didn't want the award to be made public in any way or disclosed to anyone. But that's what the law said, right? And so that could have been clarified in the arbitration provision. The discovery process that we talked about, whether you're going to limit depositions, force everybody to use interrogatories, whether testimony is going to be done via live witnesses or sworn statements, whatever it might be, you can add this all kind of into the provision, right? Remedies including emergency relief. For those of you that don't know what emergency relief is, occasionally there might be an emergency arbitration that takes place if there's some issue that has to be resolved right away. That's not handled by necessarily the merits arbitrator, but a secondarily appointed process arbitrator. Again, I don't see it commonly drafted in arbitration provisions, but it would kind of clarify what happens in those types of time is of the essence situations. In the assessment attorney's fees cost of the arbitration, some becomes prevailing party provision. It is very important to be highly specific if you are going to have a prevailing party provision about what the prevailing party gets. What I typically see is the winning side will submit a attorney fee application, and I don't want to say sneak it into the attorney fee application, but in addition to the attorney's fees that they're seeking, they start adding in the cost of the arbitration, the deposits they paid to the arbitrator, the filing fee and the administrative fees to the arbitration, room rental fees, hotel rooms, plane tickets, meals, all this kind of stuff, the greater cost of the arbitration. Well, you need to really take a look at what the provision says. Are you entitled really to get everything back, or is it just the attorney's fees? So if you're the drafter of a contract and you intend for them literally to get every dime they spent back on the arbitration, really spell that out, and be clear about it. And then the type of arbitration award you'd expect, standard, reasoned, simple, whatnot. A simple award that simply can be a couple of sentences explaining who won and what they got is going to be the least expensive to draft. And if you have a relatively small case, let's say you're issuing an award under $25,000 or something like that, that might make the most sense. But on the other hand, if it's a multi-million-dollar award, tens of millions of dollars, hundreds of million dollars, billions of dollars, then you're going to probably want a reasoned award that really explains how the arbitrator, the panel got to reach the conclusions that they reached. Because if you have to go to court and file an enforcement action, I think it's going to be really hard to enforce a $100 million award in court, where the judge is reviewing the award and the arbitrator didn't actually explain how they got to their numbers. All right, poorly drafted arbitration clauses result in a failure to meet the parties' expectations. Well, what are the parties' expectations about arbitration? Why are we using arbitration in the first place? Because it's a faster, more cost-efficient way to resolve disputes in traditional court. And right now, even on the biggest cases, it's still a lot faster to resolve a dispute. I think I saw in California, the average federal district court in California, it's about 3 years, last I checked, from the date a demand for jury trial is filed till you actually get the jury trial. Most arbitrations, I think, can be done within a year, so it's about a third of that time. But the expectation is going to be faster and more cost effective. Costs that quickly spiral out of control with the advantage going to the side that is more money to spend on the process. Arbitration was never designed where if you have more money to spend on the arbitration, you have a better chance at winning the arbitration. It's designed to be a fair and neutral process, regardless of your ability to pay for things. And we see this all the time. Usually respondents or well-funded respondents will start asking for all sorts of exotic discovery. They'll demand a 3-week evidentiary hearing when maybe 1 week is probably enough time. There's just really protracted motion practice on just about everything. Every motion they file, they're going to demand an oral argument. They're not willing to just let the arbitrator decide it on the papers. Listen, you can write into the arbitration provision as much as or as little as you want about, controlling the process, the discovery process, the timeline, whatnot. It's something that you might want to think about if you're trying to keep your arbitration costs down. And then ultimately, the side that has more money to spend on the process, their goal is to basically force the other side into a less than desirable settlement agreement. So yes, the case does settle prior to the evidentiary hearing, and you might save some money that way by not having the evidentiary hearing, but usually the side that was forced into the bad settlement agreement is not too happy with that result. Unnecessary court intervention. If an arbitration provision is not drafted clearly and the parties disagree with the the provider's interpretation of it or the arbitrator's interpretation of it, unfortunately, sometimes we see these things going to court. We see one party filing a TRO to stop the arbitration in its tracks, to have a judge look at the arbitration provision and answer some of the finer points of what the process of the arbitration should be. Okay, the second you go to court, court's expensive, and court's an extremely public process. Probably somebody put an arbitration provision here because they didn't want all their dirty laundry hanged out in the air. As soon as it gets to court, that's where it ends up. And then, of course, the arbitral process itself being blamed for the unfortunate result, not the poor arbitration clause. So many people I talk to that say that they hate arbitration, they've always had a bad experience with it or whatnot. I can look back to like their arbitration provision and I can be like, boy, that was a really bad one. This is a 200-page contract, and somewhere on page 197, section 2, clause 3A, there's a one sentence arbitration provision that doesn't make any sense. Somebody spent all this money drafting a 200-page contract and they spent one sentence on the arbitration provision. It's not even good. Terrible. All right. If you take nothing else from our presentation today, and some of you may have heard say this before, because these 5 items never change, listen up on these 5 items. And these 5 items I compiled based on the number of disputes I've seen from the case management side. What are the 5 things most commonly argued about if they're not clear on the arbitration provision or they're missing entirely? Okay, so the rules to be used. Every provider has some variation in the commercial rules or the construction rules or the employment rules, etc., right? It's very important to have the right rules for your dispute type, because if the wrong rules are being used, you're going to get the wrong type of arbitrator. It's going to follow the wrong process. And oftentimes the rules determine who has to pay for the arbitration. So, for example, in the consumer rules or the employment rules, it's the respondent, the company that's paying for everything, right? And if that's not what you intended for, you want to make sure the right rules are in there. Unfortunately, what I see in a lot of contracts is according to the American Arbitration Association rules or according to the JAMS rules, right? There is no such thing as the American Arbitration Association rules. There's no such thing as the JAMS rules. There's the American Arbitration Commercial rules, right? There's the JAMS employment rules, right? So you have to really be specific. Don't just say the name of the provider and assume that the person, the case manager and the arbitration uh, provider are going to know exactly what you're talking about. All right, the location of the evidence you're hearing. It's going to be one city, one state, one city, one country, right? Do not give people options. Do not leave this section blank. Everybody is going to want home turf advantage, so they're going to argue the location of the hearing should be closest to what suits their needs best. All right, will the arbitration be heard by a single arbitrator or panel of 3 arbitrators? Some providers, if you're silent on this, are going to make this determination for you based on the size of the claim. And we talked about this in the past, that a 3 arbitrator panel is way more expensive than a single arbitrator panel. And at least at AAA, the threshold is only a couple $1 million, the difference between 1 and 3, right? So you really should be specific about this. And I wrote, do not just rely on the word arbitrator in the singular to convey what you're trying to talk about, because courts have interpreted arbitrator that could mean a single arbitrator or a 3 arbitrator panel. So you're going to want to use the word single or the word 3. All right, choice of law provision, obviously very important if dealing with 2 different states. You want to have the procedural law and the substantive law explained. And then does the arbitrator have the authority to award attorney's fees and arbitration costs to the prevailing party? What constitutes those costs? So that's going to be very important to lay out. Okay. All right, and then this is just example general arbitration clause that I drafted here. Again, you could use this for any provider. I even wrote in fill in the provider name. But this is going to hit all 5 of those of all 5 of those elements I discussed for a properly drafted arbitration provision. Okay, and I will turn over this part of the presentation to my colleague Stephanie. Take it away.
Thank you, Aaron. So this is going to be this slide is going to be very similar to just what Aaron just discussed. This is how we can keep things down in the pre-dispute stage. So one is to require a cooling off period in your ADR provision. So have some time built in, 30 days before a party can file an arbitration, some meet and confer time built into your arbitration provision in the contract. And then again, consider a mediation step. So with this, though, I do want to emphasize that having some discovery, some document exchange prior to that mediation step is something that may be important to include. You want a full picture when you go into a mediation, or at least a fuller picture and you don't want to waste your time or your client's time and money in having to do a mediation, having that be a prerequisite to filing an arbitration, if nobody has any reason to really proceed with some discovery exchange, some document exchange. And then, like Aaron said before, making sure you're picking the appropriate rules for your contract type. So I won't go into the rest of these too much. We did, kind of talk about these a lot in the earlier slides. So the next slide, Aaron. And so now you're in arbitration. Something's been filed, and you are now in front of a provider, and the parties are ready to move forward. Here, you want to, and I cannot emphasize this enough, one of the biggest benefits of arbitration is that many times you have control, or you have the ability to help select your arbitrator. Your decision maker it's usually that decision is in the hands of the parties and their attorneys. So this selecting the right arbitrator for your case may be the most important decision you make, at least in the beginning stages of your arbitration. Depending on the case, you want to make sure that if you are looking, if this is a claim that requires subject matter expertise, then select an arbitrator with that. Review their resume, talk to your case manager about that.
Can I just add something to that real quick, Stephanie?
Sure.
One thing that I unfortunately see a lot in the arbitrator selection process is I will be going over the qualifications that the parties are specifically looking for in an arbitrator to handle their case. And I'll inevitably get one side that says they absolutely have to be a retired state or federal judge. If I see a single attorney arbitrator on this list, I'm going to absolutely strike them outright. Okay. Subject matter expertise matters way more than somebody spending any time on the bench, especially when you're dealing with really technical type things. Stephanie and I both work with our national technology practice here at AAA. I would take an attorney arbitrator that understood something about a complex technology matter, like a semiconductor, IP dispute or something like that, any day over some, judge who's been off the bench for 10 years that knows nothing about what I'm talking about. So do not discount someone simply because they're not a retired state or federal judge. Okay.
The other items that you'll want to focus on are maybe meeting with opposing counsel to discuss how to work out any procedural issues that you have before. Is there going to be a jurisdictional issue? Is somebody objecting to arbitration altogether? Is somebody objecting to the jurisdiction of this provider? Make sure that you have tried as best you can to work with opposing counsel to see if there are any of those issues. If you think a motion to compel is going to be necessary, it may be best to do that in advance at the same time. Now, I know we don't always know. You may not always know before you get into arbitration that someone's objecting, but if it can be discussed beforehand, then try to. We have, I want to say 90% of the cases that I've worked on, opposing counsel work really well together. Of course, there are some cases where you see the back and forth, but most of them, opposing counsel, even if they're not in agreement, they can work together through some of those issues to help save their clients some time and money. And then this is just a list of different things that you're going to want to consider. A joint stipulation of facts for your arbitrator, protective order. If you know that, if this is a tech case or an IP case or something where there's some trade secret issue and you want to have all of those, that's going to come up, draft it beforehand so that all you have to do is have the arbitrator ready for it to sign, have those, do the red lines back and forth before you get it to the arbitrator, so that you're not also paying the arbitrator for their back and forth while you're doing it. And then again, depositions, interrogatories, if necessary. Try and talk to opposing counsel before you get on the phone with the arbitrator about what each side is looking for. That will also help keep the costs down for the arbitrator to potentially have to referee any discovery issues at the very beginning. And again, I cannot stress enough trying to address, if you can, any jurisdictional issues before you even get to the arbitrator appointment stage. Next slide.
All right, and then one jurisdictional issue that's specifically within arbitration that really might make more sense for a court to handle even before an arbitration is being filed is occasionally I'm reached out to by a claimant that's in the process of filing an arbitration against what we call a third party respondent, somebody who's not named in the contract, right? And the legality of this, while not governed by statute, is typically governed kind of by case law. Different jurisdictions look at it different ways. Some really try to do everything in their power to see how this third party respondent could be somehow tied into the contract. Other ones just outright dismiss them as they're not a proper party to the arbitration. That's the exact kind of thing, even before you file an arbitration, you're going to want to go to court and get a motion to compel signed off on by a judge against a third party respondent. So they can't immediately come back once they're served saying, my client's not a party to this contract. Because then the arbitrator is going to have to spend some time deciding whether or not they're a party to the contract, because the arbitrator has that authority. And then if the third party respondent doesn't agree with the arbitrator's decision, it's going to end up in court anyways. So you could have just saved the entire step, having the arbitrator involved as well as the cost. So thanks, Stephanie. I'll advance the slides.
Thank you. Okay, so as I was saying earlier, selecting the correct arbitrator for your case is the most important decision you're going to make early in the arbitration, at least from the provider standpoint. I've managed hundreds of cases, and I have seen how important this step is. So, like I said, if it's something that you believe really is going to require subject matter expertise, talk to your whichever provider. We have great case managers who can really help assist. They know this process well. They know their panel well. Reach out to them. Use them as a resource to help you find the best arbitrator for your case. If a subject matter expertise is not as important, then they can help you find an arbitrator that is going to fit your client's budget. And they might find an arbitrator that's going to fit a timeline if timelines are an issue in your contract clause. What you don't want to do is select an arbitrator who doesn't have the subject matter expertise that you need, and then you and your clients are going to spend a lot of money and time trying to get that arbitrator up to speed, especially if it's a very technical type of claim. And especially for larger cases or cases where there's very technical claims or issues, one thing that I don't see very much, and I think it is underutilized, is having counsel interview potential arbitrators. So that can be very helpful. It can be very helpful in also keeping the arbitrator selection process moving along quickly and efficiently. Sometimes we'll have parties who they know what they want, but they're not seeing it in the list, or they don't know anyone who might make a good arbitrator for this case. And there could be a really good arbitrator, just not the experience isn't listed in that arbitrator's resume. So what I've had happen is they will send me a list of questions together that they've worked on together, that they're both in agreement. We can ask the arbitrator. We'll all get on a phone, we'll all get on a Zoom call or a Teams call, and they'll be able to ask the arbitrator those questions, or potential arbitrator those questions, and both parties are present, so they're both going to get the answers. And then at that point, once we're done with the call, the parties and their representatives can meet and confer and see, were those the answers that they wanted, or do we need to keep looking? It really does help. Now, they're not allowed to ask to talk about the merits of the case or anything like that, but it is something that if your provider offers it, you should use it if you need to. And if they don't, you should ask.
Yeah, I was really surprised to see that. Stephanie's been here, 9 years? And I've been here close to 7. And I asked Stephanie, how many times in your career at AAA had you seen anybody actually do an interview? And she said once. And I
Mhm.
said the same thing with me. I've only seen it happen once too. I don't know why more parties don't take advantage of it, but it's a fantastic way to really get to know an arbitrator beyond just kind of what you read on a piece of paper. A couple things I want to add here. I always like to think, beyond the rank strict list, if you have a good working relationship with opposing counsel, why not select the arbitrator together? Um, just, I'm a pretty trusting person, but in this process, you really have to know who you're dealing with on the other side. Of course, I've seen situations where you send the parties 10 names. Um, they try to discuss the names with each other. One side says they like these names, the other side says they like these names. Inevitably, they come back to you and say, like, let's go ahead. We just want to do it as a traditional rank and strike list. And one side strikes the five that they knew the other side wanted, and then vice versa, right? We see that happen here. So if you truly are getting along with the other side and you actually trust them, then you should have a elaborate discussion with them. Be honest about the process. If you're sent a bunch of names, and let's say out of the 10 names, you like three of them, and you tell the other side you like them, if you have used them as an arbitrator in the past, especially recently, you really need to disclose that, because the last thing we want is the arbitrator is certainly going to make those disclosures when they fill out their disclosure paperwork, and that can really um, end up costing a lot of extra money and taking a lot of extra time. Um, all right, next slide here.
Mhm. So again, these are just other things that you can do to help promote efficiency in your arbitration. And it's things that can be done prior to the preliminary hearing that takes place with the arbitrator. So um, talk about when you can schedule, when you can both schedule, or if there's more than two parties, when everybody can have what are some mutually convenient dates? How long do you expect the hearing? Uh, I have a case now where the parties had booked 5 days. It's now 8. And so they had discussed it. They had done everything, by the book. So it does come up that as you go along in the case, as you do more discovery, you realize, oh, we have 4 or 5 more witnesses than we anticipated at the beginning of this case. But if you can talk about it beforehand, it's easier to add on dates after you've already had some set time than try to do that a lot later. And then if you can, witness availability is always really good. Party representative availability is something that multiple times I've been on preliminary hearings and, counsel will say, well, I can do this date, but I have to check with my client.
Hmm.
And then then it further delays being able to even set your hearing date, which kind of delays being able to set discovery cutoff dates and things like that. So just think about all of those things if you can in advance with opposing counsel. Again, the protective orders, and then make sure that you address any choice of law issues. So what does your contract say? Which rule is going to govern? Is it going to be the FAA? Is this going to be under state law? Will the CCP rules apply? All things that I have seen where parties have had to sometimes the contract isn't clear. There's some ambiguity. So if you may not agree, you and opposing counsel, one party might say, well, no, New York law is listed in this clause in the contract, and California law is listed right next to the ADR clause, so California law applies. If you know it's going to be an issue, raise it with the arbitrator at the preliminary hearing or beforehand in case the arbitrator wants briefing, or try and see if you can come to an agreement with the opposing counsel on it.
And another
Uh,
thing to keep in mind too with all of this and everything that Stephanie's saying is, for those of you that are watching this presentation today that are not advocates but actually arbitrators yourselves, you should have a letter customized to yourself as far as what you want to discuss during the preliminary hearing. Um, Basically, homework in advance for the parties to complete before the preliminary hearing, so none of this is like a surprise to them. You should send a letter out in advance saying, "Hey, please meet and confer on all these issues so we can have a quick and efficient preliminary hearing." I would say that unfortunately, for the large complex cases that I've case managed, maybe 30% of them have actually had to have a second preliminary hearing because none of these issues were able to be worked out on the first preliminary hearing. Some of it's because the parties didn't know what they were going to be working out, which I kind of find it hard to believe, but at least that's what the parties would say. But again, a second preliminary hearing is another hour or two of build time by the arbitrator that could have not been spent. And this is about keeping arbitration costs down. Sorry, Stephanie, continue.
No, go ahead on to the next slide, please.
Oh.
So these are also, I'm going to focus more on the have the parties talked about the scope of the arbitration? So we talked about that earlier. Have you discussed what the scope of this arbitration is? Sometimes there's multiple claims, and I've had cases where they have both state court claims and then arbitration claims. So making sure that the arbitrator in advance knows what claims they're going to be hearing and what claims are being taken care of in state court. And then if there is a state court action, making sure that everyone is aware of any outcome or any orders that take place in the state court action, especially in case they inform anything that has to take place during the arbitration. So just, keeping those lines of communication open with your case manager, with your arbitrator. If it can be narrowed, if the scope of this arbitration can be narrowed, especially to help keep things moving along, try and do that. If there's a counterclaim that will be filed, most times by the time we get to the preliminary hearing, it's been about a month or two since a demand has been filed. And generally the parties will know, the other side will know whether or not they're going to be filing a counterclaim. Very rarely will I see arbitrators give long periods of time for a party to make a determination as to whether or not they're going to file a counterclaim. It's usually, if they don't know by the preliminary hearing, I want to say it's maybe 14 to 30 days that the other side is going to have to file that counterclaim. Because it really does also inform the length of the hearing, how long discovery is going to take, how many depositions each side is going to take, because if there's a claim and a counterclaim, then there might be, more discovery that needs to take place. And then a lot of providers allow for dispositive motions. And sometimes parties will say, well, we don't know if we're going to file a dispositive motion. And then they won't allow time for it in the preliminary hearing scheduling order. And a lot of arbitrators will put that in anyways, but have that discussion with the opposing counsel. Do they anticipate doing that? Normally, everybody kind of knows if somebody's going to be filing a dispositive motion, but it's better to talk about when you can file it, when you expect to be able to respond, when you expect to be able to have a hearing on it if necessary, and work that out in advance, than waiting until, 6 months into the case and the hearing is just a few months out. And now you're like, well, I want to file a dispositive motion. And if you lose, everything is going to have to be pushed out even further. Yeah. Talk about making sure that your mediation, if you're going to be scheduling one, that it's well in advance of the arbitrator's cancellation policy. So a lot of providers have provisions in their rules that, mediation has to take place or at least has to be attempted. And the arbitrators will give a mediation cutoff date as well. Working with your arbitrator, reviewing when their cancellation policy starts is going to really help if you do get that mediation scheduled, and assume that it's going to take maybe 2 weeks after the mediation date to actually get everything finished and get your settlement agreement signed and finalized. Because what you don't want to do is schedule the mediation right before the arbitrator's cancellation policy kicks in. Mm-hmm. And then you settled the case, but you're still paying for the arbitrator's time for the hearing, whatever their cancellation policy is. So you'll want to keep that in mind when you're putting together, which is our last point, drafting a proposed joint scheduling order. So again, this assumes that counsel can work together. This assumes, I've had a lot of counsel who even said, we don't belong in arbitration. Just say, you know, we're drafting this, but we are not waiving our right to jurisdiction or to fight jurisdiction. We don't agree that we should be here. That is something that you're going to want to, if you can, do it together and send it to your arbitrator in advance. They can look at the dates. Will these hearing dates even work for the arbitrator? And you can kind of get some of that taken care of instead of doing it at the end, or, you know, having to wait, like Aaron said, to have another preliminary hearing.
I've seen some parties prepare so well before the preliminary hearing that the preliminary hearing, which on average lasts an hour, I've seen some last 5 minutes because the parties were so prepared. And then the arbitrator is billing you 5 minutes of their time, not an hour, right? So keeping arbitration costs down. Again, the biggest waste of money is if you have to do the preliminary hearing twice because absolutely nothing was decided first time around. Okay, Stephanie, take it away during the preliminary hearing.
All right. So this is going to be what happens when you're on the phone with the arbitrator and you're setting out the schedule for the rest of the case with opposing counsel. Sometimes representatives join, sometimes they don't. So again, that's a personal preference of each attorney. Do you want your?
It's not required.
It's not required. I don't believe any of the providers require that, but
none of the providers require the client to be on the call. Correct.
Page limits. Page limits on both actual briefing and exhibits are something that you are going to want to think long and hard about, because when we are putting together estimates for the arbitrator's compensation for the whole case, one of the biggest issues that comes up towards the end when we're doing pre-hearing briefs and post-hearing briefs is the arbitrators will get a 200-page pre-hearing brief. It's 25 pages for the brief itself, which, you know, they'll set those limits, but then, you know, 175 pages of exhibits or more that the parties are going to have to pay the arbitrator to review, but the arbitrator didn't realize that he or she was going to get 200 pages of briefs per side. So that's something that you're going to want to think about. Discuss setting page limits on both the briefs and the exhibits themselves. I had one case where it was it was an expedited case, but the one party sent 800 pages of exhibits. And an expedited case, it was a flat rate case. So the arbitrator we had only billed $2,500 for a day of hearing and what they thought were going to be small briefs. No, it was 800 pages. So try to avoid that. We didn't end up having to bill the arbitrator's hourly rate because it's not, we weren't able to say, here, arbitrator, yes, you also have to read 1,600 pages, because I think there were 2 sets of briefs. It was a mess, but try to talk about that beforehand, because it will really help keep your arbitrator costs down. And probably the attorneys who are having to put together all those exhibits and all that brief. Then
we're starting to run a little short on time, so you'll place the rest of these on the slide. Yep.
So just, you know, make sure whoever keeps your calendar, either they're on the call with you or they are part of the service list for whichever provider you're on. We have seen where, you know, counsel won't show up because it wasn't put on their calendar because they forgot to share it with their support staff.
Yeah.
Make sure you're sharing everything with your support staff, or have them be on the call with you. Yeah. Really tailoring discovery motions, discovery issues, I think for at least on the administration side, are one of the things that really increase costs and increase length of arbitration. Tailoring it's also, you know, you hear parties complain about how you might as well have just gone to court. And it's like, well, if you're going to do court style, you know, CCP style discovery, then yes, then this is going to take almost as long as court would, and it will be expensive. It might be even more expensive because you're also paying your arbitrator. So that's on the attorneys to really try and tailor and narrow that discovery as much as possible. And then go ahead and go to the next one, because I think those are all things that we've discussed. Okay, so let's say you have to have a 3-arbitrator panel for whatever reason. Consider a streamlined panel. So consider having your chair arbitrator hear the day-to-day items, hear dispositive motions, hear discovery issues, so that you basically have a single arbitrator. The panel will be on during the preliminary hearing, so everybody has all the dates, everybody's aware of all the issues. The chair arbitrator handles everything between the preliminary hearing and the final hearing. And then the full panel will hear the evidentiary hearing. So you're basically just paying for the full panel to hear the case and then decide it. But all the day-to-day items, all of the discovery, like I said, or dispositive motions will be handled by your chair. So you essentially have a single arbitrator during the bulk of the case. That's been really successful for a lot of cases where the parties feel like they want a full panel to hear it, or they couldn't agree to not have a full panel, and the contract either calls for it, or the whichever rules were the case was under called for it. It's been really successful in helping to keep costs down, and to keep the case moving along. You're not trying to schedule a dispositive motion hearing for all of the panel needs to have the same availability. It's just a little bit easier.
Let me just add this really quick too. One concern that we have is folks will say, well, I don't mind if one person's handling all the discovery motions, that's fine. But if a dispositive motion comes up, absolutely I want the full panel hearing that. So you can customize it any way you like. If you'd like to have one person to do all the discovery motions and the dispositive motions, sure. If you want one person just to do the discovery motions and then get the whole panel going on a dispositive motion that could dispose of the case, that's fine too. And the other option is, of course, just appointing one person literally up until the evidentiary hearing to do everything. And this is a great option because it puts maybe a little bit more pressure on the parties to maybe settle a dispute, because you have this deadline looming over them where they're going to have to appoint the 2 wings as you get closer and closer to the evidentiary hearing dates, right? So that's really highly effective. Okay.
Okay. And then, so, this is just once you're past the preliminary hearing stage, setting the stage for your case, basically legal writing, be succinct, be concise, don't overpromise. And then if there was a ruling on a summary disposition motion, learn from it. Try and your attorneys for the most part, so you'll know how to do all of these things, and then focus on the key factual issues. Really just paint things as plainly as possible for your arbitrator. Give them what they need. Don't hide the ball.
Yeah. The e-sites are critical with e-links, and then hard copies as well, especially if that's what the panel requests. And then in limine motions are going to save a lot of time because you can do them during the period of the actual evidentiary hearing, as opposed to having to stop the evidentiary hearing in its tracks and get that going. Okay, sorry, we're rushing to these last ones. We're going to go a little bit past 1:30, folks. Stay with us. Was I doing this one, Stephanie?
Yes.
Okay. Presenting witnesses and evidence. So obviously a joint stipulation of undisputed facts. Not everything is being argued about in an arbitration, right? So show the panel or the arbitrator what you agree to. Fact witnesses, live testimony, or by sworn statements. Sworn statements are going to be a lot faster and a lot less expensive than having live testimony. Live testimony involves having somebody physically go somewhere, being on a Zoom, whatever it might be. It's expensive. Expert witnesses consider hot tubbing. A lot of people are like, well, what do you mean by hot tubbing? In the old days of arbitration, you used to have your witnesses your expert witnesses all show up on different days at different times, kind of be questioned one by one. Why not have them all together and just fire questions off at them all as a group? That's way you can like literally cross-examine statements, literally that one just said by referencing the expert next to them, right? It's really the most efficient way to do this. Using a witness's deposition for submitting impeachment. If you have it in writing that they've already impeached themselves, why do you need them there live testifying to impeach themselves during live sworn testimony, right? Seems like saves time and money. And then arbitrator questioning of witnesses. This is very controversial. I'm sure we have some advocates on the call today that would say the last thing I want is the arbitrator directly asking my witness for clarification or questioning my witnesses. But I got to tell you, if the arbitrator is confused about something that your witness just said, rather than getting it more confusing by going through you for the clarification, sometimes it's great to get it straight from the horse's mouth. And I'd really consider allowing the arbitrator to directly question your witnesses if that's what they want to do. All right, managing exhibits. Whether live or remote, you want to make sure all exhibits are legible and manageable for the arbitrator, both during and after the hearing. Again, common sense. Joint or separate exhibits. Obviously, joint exhibits are going to be better. It's even better if you can have joint exhibits in the same trial binder, right? That's even more efficient. And then, of course, considering the wholesale admission of exhibits, if we have to do individual admissions of exhibits, it just adds a lot of wasted time to the process. So it's not necessarily being efficient cost-wise. All right, closing arguments and issues of attorney's costs and attorney's fees. So obviously present a solid argument. Your closing argument should just be highlighting the strengths of your case, nothing more than that. Drafting effective post-hearing briefs. You want to make sure your post-hearing briefs are focusing on the strong points of your argument. And this is not the opportunity to bring up stuff that you really forgot to bring up during the course of the evidentiary hearing, because then, even though the other side will get a chance to reply to your statement, it's really not the same as cross-examining a witness or whatnot. All right. Drafting clear and concise attorney fee applications. Again, a well-drafted arbitration provision will actually explain what an attorney fee application is. Is it attorney's fees? Is it arbitration costs? Is it attorney's fees and arbitration costs? Like if you're not sure what constitutes an attorney fee application, at the conclusion of the evidentiary hearing, when the arbitrator is giving post-hearing briefing instructions and all that kind of stuff, raise your hand and ask them to get clarification on that in front of the other side so they know. All right, so we have interim award versus final award. Can a step be saved? All of us have been on arbitrations where an interim award is issued, basically letting you know who the winning side is and what they get. And then it's just a matter of figuring out the attorney's fees, where you submit your applications and then a final award is issued with those numbers in them. I don't think it needs to be a two-step process. I think your request for attorney's fees and costs can be added into the post-hearing briefing, and there doesn't need to be oral argument or additional stuff added to that, and they can just go straight to a final award. If you have an issue with this, you can take it up with the arbitrator, but I think that's a great way to save money. Should the parties draft a model final award together after the interim award is issued? So what is a model final award? Sometimes the smallest detail can be really important to one party. I had a case where the arbitrator said that the claimant was entitled to XYZ amount of money, and the check should be made payable directly to the party, right, or something like that. When the agreement between the claimant and their counsel was the check would be made payable to counsel, to their trust fund, because it was a contingency case, right? And counsel would be able to take their cut out of that and then pay their client what was left. I know that's a very minor issue. It wasn't something that was debated or argued over between the attorney and their client. But just to be difficult, the losing side said, no, this is what the award says. You don't have the authority to change it after you've issued a final award. And they wanted to do post briefing on the topic and have an oral argument. If you can change the pay to person in an award and all that, think of how much time and money this wasted. A lot, right? So just if you had drafted the model final award together, Little things like that wouldn't be tripping you up. All right, should the arbitrators retain jurisdiction post-award? This is extremely controversial. I am not a big fan of retaining post-award jurisdiction for enforcement actions, right? That's what the whole court system is for. I've seen cases where something has gone to award, or maybe it's been a settlement. They've settled, but they've asked the arbitrators to keep the case open pending uh, satisfaction of all the settlement terms, and they want them to retain the jurisdiction to help that process along. Some of these cases stay open for 3, 4, 5 years post settlement or post award. That's just dumb, and it doesn't save any money. Issue the final award. No post award jurisdiction retained by the panel. Go to court if you want somebody to enforce your award. Do the appellate rules make sense? One thing, just about every provider has some form of appellate rules. If you are unsatisfied with the result of an arbitration, let's say you're on the losing end of it and you want to attempt to vacate an award, does it really make sense to go to court to try to do that? Where, and I study kind of vacated awards, right? 97% of the time, 98% of the time, your vacature motion is going to be denied by a judge, just because the courts are really good about backing arbitration. It might make more sense to have written into your arbitration provision that if you're disputing something, it goes to an appellate arbitrator within that institution, basically to look at everything that happened during the arbitration and what the, if you will, trial level arbitrator decided and how they came to that decision, and to see if it should be reversed or something should be changed. That's going to save you a lot of money instead of using the court service, and you might even have a better chance, who knows, at winning your vacature motion. And then last but least, if the court is your only option for a vacature action, you have to decide if you're really wasting your client's money. So again, I'm speaking for myself here from experience, just what I've observed in the marketplace. Most vacature actions fail. Vacature actions fail for misapplication of law. They typically fail. They fail because one party is arguing that the arbitrators didn't follow their provider's rules to the letter of the law, or exactly the letter of the rule or whatnot. One arbitrator, the arbitrators refused to let me in discovery, let in some evidence that my entire case somehow hinged on this one little bit of evidence that they wouldn't let me admit into the case. All of these arguments typically fail. They're all terrible. I mean, I don't know if it's all terrible, but they're all terrible options to get your award vacated. The one thing that you might have a shot at is if you can prove bias, and you can prove bias via a failure to disclose issue. So you went through this arbitration, you lost, and you hired a private investigator to look into the arbitrator and their personal life. And it turns out that the arbitrator failed to disclose that opposing counsel was his sister, right? Something major like that, yeah, the court's going to vacate that award and overturn it. Things like that. But other than gross examples of a failure to disclose issue that the case probably would have hinged upon, or you can demonstrate with 100% certainty, had the arbitrator disclosed XYZ information during the disclosure period, there's no way you would have agreed to select him. You would have struck him during the confirmation period. That's when a judge will perk up their ears and maybe think about your vacature action. Okay. Again,
And so I'll just
go ahead.
Okay,
Stephanie,
so I'll just
sorry.
go, yeah, I'll just go over this very briefly. So these are things to consider in the event that we have another pandemic. Right now, I don't believe there's any mask requirements outside of maybe hospitals or doctors' offices in certain counties in California that are seeing an uptick in flu and COVID. But I can say that one thing that has persisted is the use of hybrid hearings or completely remote hearings. So just something to think about, especially as, witnesses they can be far from where you are, where you're having the case heard. Hybrid hearings have proven to be very successful. A lot of arbitrators and parties are very pleased with the ability to either appear in person and virtually have witnesses, or conduct the entire hearing virtually. So just here, this is a list of items to think about: who's going to pay for it, what to do if there's a technical failure, should we have a third party host the hearing, and sometimes if you're having the hearing transcribed, the court reporting service will do it. Just something to think about, so that it's not you or the arbitrator who is going to be having to let witnesses in, or if there's some internet issue. So that's it. This is just very, things to think about in the event that you do have a virtual hearing or hybrid.
All right, we've included our contact information here if you have any questions. Again, I'm Regional VP for California's Commercial Division for AAA. Stephanie's the VP with the Employment Division for I would describe you as the Western United States now,
Yes.
right? So
Yes, that's the
not
Western.
just California. But if there are no questions, and I will ask Rin, I believe I don't see any questions in the webinar chat. Is that correct?
Yeah, no questions.
Okay.
Okay. Then we can wrap it up, and thank you to everybody who attended today and spending some time with us this afternoon. Bye.
Thank you.